Muslim scholars, over the last 6 or 7 decades, have in all sincerity written about human rights in Islam. They have adopted all kinds of approaches, ethical or moral, legal or political, and also social. Unfortunately, their efforts do not sound convincing. The reason is that their discourse has not been linked to the Queen of Islamic sciences, namely, Islamic jurisprudence or usul al-fiqh. In this video, and a few following it, we will show how deeply embedded the foundations of human rights are in this discipline. We begin with the issue whether human rights are granted at birth. Today, the whole world believes in a system of universal human rights that have belonged to man since birth. Not only are individual rights advocated, but group rights as well for a variety of groups, including those for gays and lesbians. For example, human rights form the foundation of the UN system, and they also serve as the basis for protecting the freedom and liberties of people within states. As most of the important rights are hardwired into national constitutions, the position taken in the United States, following writers like John Locke and others, and expressed by Jefferson, is that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. As these rights are inalienable, the legal position developed in the United States is that these inalienable rights lie outside the ambit of the law and state. Thus, they cannot be taken away, altered, or suspended. This legal position can be found stated in cases like Saving and Loan Association versus Topeka, in which the U.S. Supreme Court said there are rights in every free government beyond the control of the state. A government which recognized no such rights, which held the lives, the liberty, and the property of its citizens subject at all times to the absolute disposition and unlimited control of even the most democratic depository of power, is after all but a despotism. This type of thinking became the foundation of the UN system of human rights, and most of the statements and declarations and conventions of the UN can be traced back to such views. There have been, in the West, those who have rejected human rights for different reasons. Well known among these thinkers and writers are Jeremy Bentham, Alasdair MacIntyre, and more recently David Stamos. We may use a few statements from Bentham here to highlight the position taken by Islamic law on the issue. Bentham rejected human rights, calling them nonsense on stilts. His main contention was that human beings do not possess these rights since birth. Rather, all kinds of rights are granted by the state. Not only are rights granted by the state, but they can also be taken back by the state. His famous solution was that man has two masters, pleasure and pain, and it is these two masters that determine what is right and wrong. Further, all legal and social systems must take actions to maximize human happiness based on the pleasure principle. This led to his famous principle of utility. MacIntyre, while agreeing with Bentham in the rejection of human rights, says that there are no such rights, and belief in them is one with belief in witches and in unicorns. He does not accept the idea of utility, however, and considers it a fiction. He maintains that human life has many complicated features, and an understanding and satisfaction of human desires is highly complex. Thus, the notion of summing them either for individuals or for some population has no clear sense. In Islam, the foundation of all laws, rights, obligations or duties is the Sharia. The Sharia has existed for mankind from the start. After recalling the laws given to the Jews in that they were once a chosen people, the Quran says in chapter 45 verse 22, "And after all that we have now established you upon the authoritative Sharia, so follow it, and follow not the whims of the ignorant." The protection of the ignorant will not bring you any gain in the sight of Allah. It is only the unjust that seek protection of the unjust, one from the other. But it is Allah who is the protector of the righteous. These are clear evidences, guidelines of the laws for the people, and a guidance and mercy for a nation with sound faith. The eternal Sharia then creates rights and duties for man, as stated in chapter 17, verse 13. Every human being's rights and duties we have fastened to his own neck. Writers have been interpreting a word in this verse to mean fate, but the jurists take it to mean human personality or dhimmah, which is a receptacle that holds all rights and duties. The Sharia created human personality with all rights and liabilities through a covenant or social contract. which humans concluded with their creator. A verse in the Quran indicates that the covenant is in the nature of an amana or trust, and it is a favor from Allah bestowed on man to the exclusion of all other creation. According to the eminent jurist Al-Dabboosee, it is the rights of Allah that are the real amana. Al-Dabboosee builds an entire structure for the creation of the obligations for all mankind. He then removes certain persons from the demand for performance on the basis of excuses recognized by the Sharia. He says that man becomes eligible for the allocation of rights, for and against him, from the moment of his creation. These are claims of Allah and the claims of man. As soon as man is created, his dhimmah or personality is created with him, which is a container that reflects the balance sheet of his rights and duties. This personality is a trust and is a favor for the lofty status of man. What is stated here by al-Dabboosee in the year 1000 AD may be compared with what Jefferson said in 1776 AD to the effect that all men are created equal, that they are endowed by their creator with certain unalienable rights. The rights granted by the creator through the Sharia are also available at birth, and they are inalienable insofar as it is the Sharia that has granted these rights. However, these rights are to be exercised within the Sharia, as required by the covenant with the Creator. To understand how the Sharia implements the systems of rights and duties granted at birth, we may begin by saying that the obligations are imposed on all human beings without any exception. They are imposed on Muslims and non-Muslims, the young and the old. In fact, the obligations are imposed with the act of creation of the human being. All original states, rights, and claims, therefore, flow from this initial imposition. For example, as soon as man is created, he becomes liable for the payment of zakat according to some, and so on. If a child falls on someone, he is liable for compensation for damage caused, even though the duty of making compensation is on the guardian. No one is exempted as far as the initial imposition is concerned. All obligations are imposed without regard for the will of man or his capacity to understand the nature of the obligations. Thus, a call or reason is not the basis of this initial imposition. The obligation exists for one asleep, one who has fainted, or even one who is insane. The insane remain liable for certain things when the spell of insanity is less than a day and night. In other words, the basis for such imposition is the attribute of being human or insania. Reason has no role to play at this stage. Further, there is an element of compulsion in such imposition, and the will of man or his choice has no role to play. As soon as the rational faculty develops, the demand for performance is activated. This is associated with puberty when the dhimmah is said to be perfectly developed. The demand is made through what is called the divine communication. The relationship of the original imposition and the demand for performance is explained by al-Dabboosee through the example of the purchase of property. It is like saying to the buyer, "You incurred a liability through your purchase. Now pay up the price." It is a demand for performance. The initial imposition of the obligation may be conceived of by saying, "The obligation has been created, and you will one day be tested and tried through the demand of performance." These are two positions represented by what we call two types of legal capacity: the capacity for acquisition of rights and the capacity for execution or performance of duties. Capacity for acquisition enables a person to acquire both rights and obligations, while capacity for execution gives him the ability to exercise such rights and perform his duties. Performance depends on two things: the ability to understand and the ability to undertake the act. The first depends on reason and the second on physical soundness. These two characteristics provide the ability for bearing obligations. As human beings differ with respect to the rational faculty and its perfection, and it is difficult to fix a standard for it, the lawgiver has associated it with the attainment of puberty. Puberty in the eyes of the law stands in the place of reason and discrimination. Likewise, physical ability is also necessary, and the Sharia does not impose an obligation to do the impossible. Al-Dabboosee first lists the claims or rights of Allah as follows. First, that all human beings examine and ponder over the signs that indicate the existence of Allah. Second, that all human beings then have faith in what the evidences or signs necessarily lead to. Third, that all human beings undertake acts of worship. Fourth, that all human beings be held liable for the consequences of undertaking acts prohibited by Allah. He then discusses the 6 cases in which liability is either suspended or is removed. The first 5 cases pertain to the minor, the insane, sleep, forgetfulness, and the woman undergoing her menstrual cycle. The case of the non-Muslims is complex, and there are many debates about their being the addressees of the divine communication. The unbelievers are like all other human beings with respect to the covenant and the creation of the dhimmah. They are addressees of the divine communication insofar as they are called upon to believe in Islam and become Muslims, because the Prophet, peace be upon him, was sent for all mankind. If they deny, that is, become unbelievers, their dhimmah is extinguished as far as the rights of Allah pertaining to acts of worship and prohibitions are concerned. The reason is that their act of denial is the gravest of all offenses, and they will be taken to task in the hereafter. If they convert to Islam later, they are not held accountable for their religious obligations missed in the past, as Allah has promised them forgiveness. They are addressees as far as the penalties are concerned if they are within the Dar al-Islam, and these will be applied to them if they are found guilty. As for matters other than acts of worship and penalties, their dhimmah is intact. This dhimmah is distinguished from the contract of dhimmah that they conclude with the Muslims. All that has been said so far was to show how rights and duties are granted to human beings at birth. What remains to be explained is how human rights, or the rights, liberties, and freedoms of human beings fit into this structure. This will be the topic of the next video, but a brief statement may be made. All the rights and duties granted by the Sharia are divided by Muslim jurists into 5 types: obligatory acts, approved acts, prohibited acts, disapproved acts, and acts that are permissible. It is the last category of permissible acts that covers not only the bulk of Islamic law, but all human rights, that is, liberties, freedoms, and rights. This area will elaborate it in detail in the next video.